So I'm Suzanne McMurphy. I'm an associate professor in the Department of Sociology, Anthropology, and Criminology at the University of Windsor. The project I'm going to talk about is a policy analysis study of a new piece of legislation which was intended to identify a group of youth called youthful offenders. And the purpose of this legislation was to reduce the number of youth who were being waived into adult court. So the legislation was implemented with the intent of making sure that the number of youth that were being waived would not get any larger than had been in the previous decade, which was approximately 25. We were called in to examine how many youth were eligible to be in this category, and so provide the court with some information around what they might anticipate in terms of treatment and space that they might need to respond to youth who were waived into adult court. So when we started, there were only 25 that had been waived in the last decade. Within the next year, after that legislation was implemented, 88 youth had actually been waived to adult court, which is an increase of around 250%. So clearly the policy had the reverse effect that the legislators had intended. And so we then shifted our research project pretty radically and decided, instead of looking at it from a quantitative perspective, we would do a qualitative study and begin to look at the case files of the youth that had been waived prior to the legislation being implemented and after the legislation was implemented, to see if there were any differences in the factors, types of youth, types of crimes, like why all of a sudden did this policy have the reverse effect. The quantitative numbers weren't providing us with a story of what had happened when this policy was implemented. And we decided that the only place where the information was actually going to be found would be in the qualitative case files. So we used three methods in the study. One, we did a content analysis of the case files of the youth who had been waived to adult court prior to the piece of legislation being implemented, and then the case files of the youth after the legislation had been implemented. We also then interviewed professionals who were involved in the cases, and then we did something called process mapping, where we asked people in different jurisdictions to map for us how the piece of legislation was intended to be implemented. It was only through the qualitative analysis that we were able to identify what was going on in the implementation of that piece of legislation in the background. It wasn't going to be found in the numbers. It was only going to be found in the written documentation. So we were in a really privileged position in this particular location because we had already been doing a number of projects on their criminal justice systems and their juvenile justice systems. So we had access to a lot of information. So we were already in a relatively privileged place, both with the legislatures as well as with the agencies that we had been working with. So we had access to an awful lot of information to begin with. And in that space, we needed to be very aware of our role and our access to information that was both very confidential, sensitive, reflected on both the legislature as well as the agencies that we were examining. So we needed to be very careful about our position. We were clear as researchers that whatever answer arose was the answer that we would go with in terms of how the legislation was being implemented. However, we also were very clear that we were in one of those very sensitive nexus between being a researcher, being a consultant in that privileged space. This was actually part of a larger national study of juvenile justice systems across this particular country. And we had been in this particular place helping them revamp their juvenile justice systems and to look at treatment modalities and different kinds of interventions available to them or should be available in their systems. We had not intended to do this project, except that this piece of legislation got passed while we were there. And they thought, well, while you're doing the rest of your other study, why don't you just give us a sense of what might happen when this legislation gets implemented? And that's when we said within a year, as I said, it went from 25 to 88 unexpectedly. And so we ended up in that project. We were coming at this project from a social care perspective. So there are a number of different research questions we could have asked, but we were coming from the perspective of how do we support children in trouble with the law? How do we create treatment systems? How do we create safe spaces for them? And so we were coming at it from a care perspective. So as a result, when we began to look at the factors that affected whether or not youth were being waived to adult court, we took it from that perspective of what were the kinds of things that potentially had gone wrong for these youth, what kinds of things were not available to them, were there systems decisions that were being made that were unfair, unjust. We were coming at it from that particular perspective. But there were multiple other perspectives we could have used. We could have taken a punitive perspective, we could have taken a punishment perspective, we could have taken a law enforcement perspective. So there were different ways we could have addressed the issue, but we were coming at it from a care perspective.